Okay.
So welcome everyone. I'm going to do the banner that we talk about all the time now. Well, thanks everyone for being a little bit patient. We had a couple of technical difficulties before, but we had everything all worked out. So happy to have Hanan Isaacs back, my go-to employment attorney, to have yet another conversation as I wind down these LinkedIn Lives, because it's starting at the end of next month, I'm going to be going to monthly. I'm really looking forward to checking in with different people. So what have you found that's changed in the last few months, or is there anything specific that we need to be aware of more specifically since then?
So things change every day
Right.
in the employment law world. And I say that not as a point of pride, but
Okay.
more a reality. So there are things that are happening today that you and I have no idea. We'll find out next week or the week after. So we try to catch up on these things. My paralegal Shelby helps me with our programs when we do it for a PSG of Mercer or
Mhm.
the Breakfast Club or other places. We sort of take a measure of what are the newest changes and trends. So I
Mhm.
can talk about what mostly is happening
Sure.
that I see is, first of all, I reinforce to people New Jersey's a great state for employees. It's imperfect, right? We have a system that's basically at will, which I personally approve of. I think it's a good thing that people can leave their position if they want to,
Mhm.
without legal consequence. And there could be a consequence if you have a true employment agreement that says, Ken agrees to work for 12 months at a salary of X doing this and that. There's going to probably be a penalty for, early leaving or early firing by the other side. But absent an actual contract like that, most employment is at will. So the company can dismiss people for any reason, as it's said, or no reason at all. The only limitation is it cannot be for an unlawful reason. And this would be for reasons of discrimination based on age or
Mhm.
gender or disability or religion or things like that. As long as the employer steers clear of those things as a bad motive, how about this? Employer is wrong about you, Ken.
Mhm.
The employer thinks that you're doing a terrible job, even though you know you're doing a great job, and other people are reinforcing you're doing a great job. I tell people many times a month there's no legal action against stupidity or bad judgment, or influences like that. We don't like your personality. You don't fit in here. You know, People actually make judgments like that, and they can lawfully do that, even if it hurts them, even if it hurts their company. So, in that setting, what I tell people is your best remedy is when you see that writing on the wall, best to start looking elsewhere as quickly as you possibly can. Keep your network going in that way.
So that brings up a question, actually a couple of questions. First of all, if I'm working now and yet I want to be passively looking, and I do it on my own time, and no one really knows about that, is that something that I have to be concerned about? Let's say I'm looking for a job, I'm doing it on my own equipment, I'm not doing it during work hours. Um, is there anything I have to worry about legally, or am I able to do that because it doesn't necessarily impact my work performance?
I would say there's nothing for you to be concerned about. That's literally your business, your time, your future stream of income. So I would not worry about that. I say to people, the biggest concern you have is not what's happened in the past.
Hmm.
You have to remember the past, we have to learn from it, But the biggest piece for all of us is the stream of income going forward. And if you can't make it where you are, or you're unhappy where you are, then the future looks like find something better. And that's really hard for people. A lot of times people feel like, whether they're feeling somewhat insecure or they're feeling like, who's going to hire me at whatever, my age, my stage, I suggest to people that you be as brave as you can be and do the things that Ken Lang tells you. Good advice for networking and creating those opportunities and cross-pollinating, all of those things. It's basic. It's kind of like in the old days we called it shoe leather, like walking around, finding this, checking that out, doing your research. My good friend Alex Freund, who I know is a friend to Ken and his people, Alex would say you always need to be looking out there and figuring out some things. It's not a sign of disloyalty in any way. It's more a sign of, hey, maybe the way things are here may turn out not to be so bad, or I'm getting enough things out of where I am that I don't feel attracted to go to that other thing. So a lot of this is basic good
Jim Locascio mentioned something called the 90-day warn in New Jersey. For people who aren't aware of it, what exactly is a warn?
So this is the law of New Jersey and some other jurisdictions basically say if you're in a company that's large enough, has enough locations in the state or even outside the state, and the company is considering going out of business or eliminating plants and equipment and this and that, they, under certain circumstances, that group owes notification to the entire employment staff. We are planning within 6 months to close our operations here in New Jersey. We're going to some other state or some other country. And if the company fails to do that, then there are penalties. In essence, they have to give more severance to the staff than might otherwise have been negotiated or required. So, but that's not always. Okay. That's, especially if it's like a 1-to-1, this employee or those 10 employees are being laid off or whatever. There is not that duty to warn. The duty to warn, I started to say New Jersey is a good jurisdiction, but it doesn't really, the landing is not necessarily always going to be soft.
Right.
So basically when I teach this work, I call this the real handbook, not what they tell you, but what actually the law of your jurisdiction has for you. And there are certain things to soften the blow, but it's never going to eliminate the blow.
The other question I've started to get, because I'm actually doing career counseling at Lehigh Harris, and they have an end date that they're no longer with the company, but they still have a severance package that pays them out, let's say, another 1 or 2 or 3 months. So if they're going to do a LinkedIn profile, is their end date reflective of the last date that they were there physically, or that can they extend it because they're technically on the payroll of the company? And is there any concern for misrepresenting themselves? Because that's a question a lot of people have, and I don't claim to really know the answer, but I'd be curious.
So just go through those essential facts again. You're saying somebody is on a severance.
I'm working at a company. This is March 19th.
Yes.
So I'm being let go at the end of March.
Yes.
But I'm going to have 2 months severance after that. So technically, I'll be paid through the end of May.
Correct.
But April and May, I won't be a member. I won't be an employee there per se, but I will be getting income from the company.
Correct.
So is my last date there the end of March, or can I portray it as I'm going to still be there through May? Because technically, I don't know if I'm on the payroll per se, or maybe I'm coming out of a different bucket. And that's a question I get, and I don't necessarily know the answer to.
Right. So what you're raising is an important issue. I'm going to say it's a matter of the optics.
Okay.
Right? So from that employee's perspective, they would rather say my job is extending until X date. The legal reality is your termination date is the one that the company says March 30. And if they're paying severance, you're no longer participating as an employee. For one thing, unless it's also negotiated, a lot of times they'll say your medical benefits stop, your contributions to 401k stop. There are, your vacation accrual stops. So those are internally, they're very important. But how you portray it, it doesn't offend me if somebody says I'm employed through May. Like, so what? Who's going to probably care about that? That's you uh, portraying yourself or depicting yourself in the marketplace in a certain way. But the
Yeah, I was
reality
asking.
is March
Yeah,
30, if they tell you you're done, that's your official end date.
right. I
And
was
they and
asking
they
for like
they
enough.
they do, they do that also for liability reasons,
Hmm.
right? Because when you're an employee, certain things can happen. For example, you could get hurt on the job. If they're using kind of a squishy, 2-month thing, and you walk into the building or near the building, you fall down, are you covered by workers' comp? Or are you going to sue them as a stranger to the facility? So legally, there's an important distinction, but I would say, kind of morally, ethically, nobody's going to care if you say I'm being paid through the end of May.
Okay, that's a good. The other thing people ask me a lot of times is when they're going to go back and check on your employment history. Um,
Yes.
what is a company allowed to say? Are they allowed to talk about your performance, or are they just allowed to quantify this was your start date and end date? Because that's a question I get a lot of too. They don't want to come across in that way necessarily, but they're also legally there may be things the company can and can't do.
So I just want to go back to one quick thing. New Jersey
Sure.
has a very unique system in this way. Um, your severance is not conditioned on your working one more minute. So if somebody says you're getting 2 months of severance, you don't have to do anything for that. And that's like 99% of the time. Some companies are a little strange that way. They'll say, if we're paying you, you're still working. Okay, that's not really severance. You're still working. Um, but you can get your severance pay at the same time as you get your unemployment benefits. New Jersey has that rule. So they could be paying you, 2 months, 4 months, whatever. And then simultaneously, you can apply and say, my last day was March 30. I want to get my unemployment benefits. And you can simultaneously be looking for other work. So there's a system there. Now, interestingly, for any of your listeners and viewers from New York, that state is completely different. You have to get your severance 100% in your pocket before you're eligible to apply for unemployment benefits. That's just how they do it. So that's a very, very big difference. Okay, so I'm done with my supplemental answer.
Okay.
Tell me your question again.
So my question again is, what legally can a company say or not say if
Ah,
they're checking back your work history? Is it just start date and end date? Are they allowed to talk about how you performed? Legally, what can they or can't they
okay.
say?
So I'm going to try to keep this really simple.
Sure.
I'm going to start with if an employer gets a call from a recruiter or the next potential employer, legally they're allowed to tell the truth about you. Whose truth can they tell? Their truth. As long as it's not malicious and defamatory, and I've gotten these calls. In fact, sometimes I've made these calls. So and so's applying for a job, and I'm asking, Ken, I understand that person worked for you. Yes, they did. How long was it? Would you hire the person back? Tell me what you liked and didn't like. What's their best qualities? What's their worst? Anything Ken tells me has what's called a qualified immunity because public policy says Ken's allowed to tell his truth. I'm allowed to ask for that truth without the employee having a cause of action for saying, Ken, you killed my job prospect. Now, they could say that, but you'll win that case. On the other hand, most employees, most of the time, don't want the employer to do that. And they will actually negotiate inside the severance agreement for a provision that's called, I want a neutral reference. So HR should be contacted. They should say my name, my title, my length of service. They shouldn't say anything about my salary unless I ask them to say something about my salary, in which case they should say something about my salary. So whether the company chooses to honor that, which they should, you're not there when the calls are being made. Sometimes a supervisor is conflicted because they don't really like you and they don't want you going to the next job, or they might know somebody at the next job. They shouldn't do that. They should, if the agreement says neutral, that's what it should be. If there's no agreement, then the immunity piece comes in. And it's only qualified because if you become malicious about it and you try to hurt somebody's prospects in the marketplace, the employer can be sued. That does happen. Now, sometimes the employee doesn't get the next job and they think that you defamed them. So it can be a little messy, which is why most companies, most of the time, don't want to talk about it. They'll just do name, rank, serial number.
So I'm putting this up here from David Chuckman, relaying the example before, and it's true. If you use March 31st on applications when you're applying for a job and the new employer does a reference check, and there's a difference, they may question the answer. So you want to be consistent, basically. If you ended on March 31st, you shouldn't say you're working after March 31st, I guess, on LinkedIn if they question it.
Right.
It's just about being consistent. I mean, that's what I'm trying to read into what Dave says.
Yeah. I mean, I appreciate Dave's point. It's an excellent one. I'm saying the reality is that people get nervous and they say, I don't want to look like I'm not working. So there might be a way that you could say, I'm still in connection until May. But, it depends. Does the employer want to push that, or a recruiter? What are your activities? What are you going to do? Interestingly, a lot of times severance agreements, and I review probably 60 of them a year, they're all a little bit different. And the employer's attorney always writes them. And then we redraft some things or make some suggestions. There's going to be something in there that says the employee or the former employee is obligated to continue to be helpful to the employer. There could be lawsuits. There could be regulatory investigations. There are lots of things that they may need from you as a former employee, and that's part of your deal. So you're still kind of like in the family. You're transitioning. That's what you're doing.
And as Linda put up, as part of your exit interview, ask HR what they will report as your termination date.
Excellent suggestion. That's a way to handle that problem completely. What are you going to report about me? And that way you're going to be consistent with that.
I actually had an issue in 2008. I was let go from UPS. And when UPS reported it to unemployment, they said I resigned, which I did not do.
Right.
So I actually had to hire an employment attorney to actually be the go-between between the Department of Labor, and UPS didn't fight it, but they were hoping to pretty much, I don't want to say pull the wool over anyone's eyes, but even the termination agreement didn't reflect that I resigned. Right. So I don't know if that's still common or not, but you do have to do due diligence when you lose your job and not assume you're being misrepresented.
Right. That is a very big issue because some employers are allergic to being described as they terminated somebody. They always want somebody to resign. Some of them say, if you don't resign, we will fire you. Unemployment, Department of Labor in New Jersey, deems that type of pressured resignation as a firing. So so if you say, I didn't quit, I was pressured. Yes, I signed a resignation letter, but only because they told me if I didn't, these bad things would happen. So the employees don't know. They don't understand. I tell people, make them fire you. That's the important thing. Because if you don't get fired, you can't claim your unemployment benefits. That's the bottom line. And if you do quit because you feel a lot of just every day pressure, you're getting migraines, you're feeling sick, you just can't stay anymore, I tell people, go ahead and quit. Now, if the environment was truly oppressive, and this is kind of like an interesting little quirky thing, you can actually make the case to unemployment, I was constructively fired. It was almost like they set fire to my premises. I had to run out the door. But the standard is an objective one. And what unemployment uses is, would a reasonable employee under similar circumstances have felt like they could not stay?
And
And
then
it makes
it's called constructive discharge in Illinois. Had this
right.
not
Well,
happened,
it's called it in New Jersey and most places too. This is exactly what I was saying. They make it so uncomfortable, and sometimes the employer wants to do that. I mean, I won't even say sometimes. There's a lot of times, rather than go through a performance improvement plan for 45 or 90 days, or put some kind of disciplinary system in place, they're like, okay, Bill, we've just tripled your requirements under this particular employment title. You have to do this, this, and this. You're going to meet with your supervisor weekly, and they really amp up the pressure. So at that point, the person may well say, I can't stay here anymore. And actually, I'm not really, I think unemployment, I'm not going to make any little of it. I think it's extremely important as a transitional thing. But if you are employable, get another job. Just do it. Don't look back. Like who turned into a pillar of salt in the Bible? Lot's wife, Mrs. Lot. She had her lot in life, and it was salty. So she looked back. God said, don't look back. I'm saying the same thing. I'm not God, but don't look back. Run. And, so like the quicker you can get that response going and get the next thing, the better off you'll be. But if you need the unemployment, like what happened to you, Ken, if somebody listening or watching this says, hey, they're messing around with my benefits, we will push it. Now, one other piece I want to say, I have this right now. There's somebody who we reviewed a severance agreement, and this individual, lovely person, means well. This person said, I feel headachy, so I'm going to file a disability claim, right? Like with the state of New Jersey. I'm feeling like I don't want to come back to the office, even though I know they're getting rid of me into a month or so. So I want to go out on FMLA to get my leave time. I'm like, please don't do that. It's not a good look, because you know what? The state of New Jersey will come back after you. They will actually assert insurance fraud, which is a crime, right? So, and you might end up owing back $10,000 or $15,000. Who needs that? Don't do that. So I said to this person, drop the claims, tell them you made a mistake. You want to file for unemployment, that's great, because that's legit, and then go find yourself another job. In the meantime, we're going to try to get her the best, benefits that she can on severance. But you have to be careful. Like these are the guidelines right here. Be careful.
Yeah, I know what led up to it at UPS is they were putting me on a PIP, the old performance improvement plan. So once I got that, I kind of saw that my days were probably numbered, but I was not going to quit. You were going to have to get rid of me. And it was really horrible those last couple of weeks, but I just toughed it out because I know they wanted to make me leave, and I was not going to take the bait.
Well, you did the right thing. That's what I would have suggested at the time. When I teach this, we put up slides, and this is my favorite slide. Actually, is the PIP slide. It's the angel of death on a four-wheeler with a scythe, with the shadow and the mask, and we're like, get out. This, some people will say, well, in our company, a PIP you can recover from. I'm like, 1 in a billion.
No.
I wouldn't. Don't count on that. Just separate. Go your own way. Get past it. Get over it as much as you can.
So I'm going to post this, which is a two-parter here. A connection was offered a job which he accepted and was going to start on Monday. During the previous week, he posted something, and I'll show you that in a second. And the company rescinded the offer without stating a reason. So that's the scenario to start. Okay?
Yep.
So this was the post. I'm reading it here. And I'm looking at the last part. Job hunting began for me 12 years ago after working 16 years at one company. Then I've been through 8 different transitions and this and this and this, and I've been out of work 2.5 years. So if a company saw a post like that right before they were going to offer the job on a Monday, do you think a job like that, do you think the company would rescind? And I'll make it more general. If someone starts posting bad stuff or stuff that's going to put the company in a bad light even before they start, is that something that they can decide they're going to rescind an offer without stating a reason? And even though that might be the reason?
So this is complicated, but familiar. I understand what they're saying. Of course, my first piece of advice would be stay offline with stuff that could possibly change somebody's mind about you that best you can. I just think that's common sense. On the other hand, if there was a way to show that that was the reason that the company did what they did, it's a very interesting set of developments under national labor relations, where things that in the old days you would say would get you in trouble, get you fired, or possibly not hired. Today, it's looked at in the light of, is this possibly people talking with each other about terms and conditions of employment, that even though they're not immediately talking about forming a union, they're still talking with each other about the job. And that can be a very broad application. So as long as you're talking about terms, now this person was talking about their own facts and circumstances, but if we change it a bit to say, they said, I'm considering a job with this company, but they have real issues and I'm not happy. I hear that I looked at, what is that thing called? Is it Glassdoor?
Glassdoor has the reviews.
Right. I looked at the reviews. It's not looking good. And the employer says out. They may have a claim. Believe it or not, you can possibly file a grievance with the National Labor Relations Board regional office and say, I was talking about terms and conditions of employment. How about this one? One employee says to another online, the boss is a real a-hole. Don't like working for him at all. Bad. We should all leave. That, believe it or not, the employer found this out. Maybe somebody squealed. They fired this person, who then files a National Labor Relations Board grievance, and they got reinstated. I would think that's not a nice thing to say about the boss person, but it was considered a communication in furtherance of collective bargaining, even though there was no union at the time. So, I mean, it's just interesting how this happens. But I also want to say the whole thing about you're offered a position on week one, you sell your house in a different state, you move here, and then in week 5, they say, sorry, job not available. New Jersey has created a judge-made, what's called common law, right of action for detrimental reliance. You told me there was an opening. In reliance on it, I put myself in a terrible financial position, and then you pulled it. So that's one where I've had those claims. We actually approach the employer and say, you owe this person some money, So that's all I have to say about that.
So what about the role of social media? I mean, you go back to that CEO who fired all those people online. It was taped on Zoom, and then all the people are taping all the stuff as kind of a get back sort of thing. What are the repercussions of something like that? Because this is a whole new world now.
Yes.
You get fired and you get that Zoom thing, you got that meeting, you can tape it right away and you can start posting it out there, and it can put you in a good light, bad light, whatever. Yeah. So I wonder about that.
Well, it's fascinating just as a social development, cultural development. We have things today that we've never seen before. In the old days, people were embarrassed to ashamed about what happened to them. We're not seeing quite that anymore. People are actually saying, hey, you want to know how bad these people are? Let me show you the tape that they used to fire me. And this is disgusting. And they're on their, account telling everybody, this is what happened to me. I mean, what can I say? I have a nephew. I love him dearly. He wanted to go to the NCAA finals some years ago. He had a job, and he actually held up a poster that said, which was picked up nationally, I quit my job to be here. He actually hadn't quit his job. But when he went back to his job, and they're like, "You're fired." I'm going to say there's a dose of common sense. You have to kind of ask yourself, and a lot of people have terrible judgment about what should and should not be, um, preserved, shown, said about this or that. Um, if somebody came to me and said, I'm having a hard time getting a job because I posted that information, there's not a lot I can do. There could be something I would say you can mitigate your own damage.
Mhm.
Like here's a good example. Sometimes I'm in a business where at best 50% of the people like me, and that maybe is my client. But sometimes they're not so happy. So we've gotten dinged. I get these things like they give me a 1. Sometimes they were never a client. Okay, so you can't stop them from doing that. You can't demand that um, the social media take stuff down like that, like Facebook or wherever they're posting, LinkedIn. What you can do, and it's not doesn't take a lot of money. It's just time. I call it taking the graffitied wall and putting ivy on it, so you can't see it. Drive stuff to the second page. That's all you can do. If we get hit badly, we're going to be reaching out to our people who love us, and we say, "Could you please help me out here? Just post something that's favorable because this is where we are." So I'm saying the same thing here. If somebody did something that puts them in a bad light, now I would say if it's unforgivable, if like Prince Harry long ago showing up at a party dressed as a Nazi officer, that's hard to shake off. I guess he's done it. But there are things that we do that we say, I made a mistake. I should have done it differently. And if there's a way to assuage people through continued social media improvements, then that's really what you ought to do. I don't know how much of it is um, the death penalty by social media. I think most of us, most of the time, can recover from that.
Well, I mean, one of the things I counsel people on is think before you post, think before you do. Filing for unemployment is one thing, but you can't take anything back. As frustrated or as unfair as it is,
Yeah.
you really have to kind of put things in perspective that way because it will come back to haunt you. I mean, even now after 15 something years, I still would never post things that happened to me at UPS that for just out of common courtesy, because it doesn't do me any good. I may post a little bit about it, but not things that would still put me in a really bad light.
Right. So you are what I would call appropriately conservative in how you are interacting. I think that's the gold standard, but that's my philosophy. If you're a risk taker, maybe you can go closer to an edge. Um, but like I say, you have to then be able to recover from something. Here's an example where a company made a settlement with an employee, and there was something that said, don't take this information and spread it out to the public. So it wasn't the employee, it was their child who did this kind of a yuck, my dad got it over on these people and this and that. The company sued to get their money back because of that disclosure. Again, extreme example, it's not every day, but we have to be careful. And we tell people right off the bat, stay off of social media, especially if you're in the middle of a case. We don't want to be confronted with something like that. It can be devastating to your legal matter.
Even as a consultant, you're told as a consultant that it's their property, not yours. So when you leave the company, you're not going to take stuff with you. You're not going to post it up because you were employed by them. And I've seen people attempt to do that under different ways. Now, it may or may not be caught, but there's a courtesy to that, and I don't know, the same thing when you're a full-time employee. There are things you just don't do.
I think there's what I would call a right way, a wrong way, and then gray way, like questionable. We're not really sure. One thing that happens when employees leave, sometimes to make their claim later, they just start vacuuming documents and materials. Some of it's legit, some of it's not legit. We have a case right now where we're sorting through 1,000 pieces of information. exactly like that. Which side of a coin is it on? And employers are actually less and less uh, reticent to go after people. They'll actually sue. There was a pretty famous case a few years ago in New Jersey where an employee, to make their claim that they were the victim of, whether it was a whistleblowing that they were retaliated against or whatever it was, they got a bunch of, they were in a like a school setting. They got HIPAA protected student records. Good God, don't do that. So they were criminally charged. The employer said, we're going to the prosecutor's office over that. And what was as amazing to me is the lawyer got in trouble, or at least there was a question whether they were going to jointly be liable, because the employee brought that stuff like a cat with a dead bird to the lawyer and said, what do we do with this? So then all of a sudden there was a hue and cry, and a lot of lawyers said, when you come into my office, don't bring anything. I don't want to see it. We'll talk about it. I'll take notes on it. We'll decide whether or not, but I don't want to be part of, aiding and abetting something that's going to end up potentially drawing a criminal charge, which is very dramatic. And it's actually very chilling to people when they find out that that's even a possibility. But it's just to say, be careful what you take when you go.
Now, are you entitled to take your performance reviews or anything from your personal record, or is that still considered the company's, even as a paper trail? I've never been totally sure about that.
Yeah, well, that's a great question. First of all, I say to people, anytime you get a performance review, keep it. It is yours. So if you have it as part of your record, you can rely on it later. There's nothing proprietary about that. I'm not sure if any employers that I've heard of recently said you can't have it. Right. So at some point you got it, keep it. Right. If you didn't keep it, the question about whether you can get it again, there's no law, I don't believe, that you have to get your personnel file and go through it after the fact, unless and until you actually file a legal claim.
Mm-hmm.
If there's a legal claim, then that's called discovery. You can get every scrap of paper ever generated on you at that time. So short of that, some companies have policies about what you can do. New Jersey has something about an existing file, a personnel file, and you're still working there, what you're allowed to look at, how often, and this sort of thing. There is some law about that back there. But for once you leave, if you have it, keep it. If you don't have it, you can ask for it. You may or may not get it, but if you sue, you can definitely get it.
So I want to thank you very much, Hanan, for being here today. I appreciate that very much. Always good to have a previous Fairlawn night together.
Absolutely. We were in the shadow of the water tower. That's all I know.
I was going to say, what part of Fairlawn did you grow up in?
I grew up near Thomas Jefferson.
TJ, okay.
Yeah. So a couple of those streets, Dorothy Street went down.
I know it very well. Yeah, right off Morlot. Yeah.
Linden Lane. That's where I lived.
Because I grew up right off Morlot Ave, by Lindcrest Ave, right by St. Anne's, and
right. Absolutely. Lovely time. Lovely
definitely.
Time. Yeah.
All right. Thanks a lot for getting together. I look forward to having another chat later on. Thank you all for attending. Yes.
Thanks for the opportunity. I really appreciate it. You do great work.
Have a great day, everyone. Yes.
Right. Take care.
Take care. Bye.